What is up, guys? Welcome back. I'm going to pull up my live so we can show this again.
I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this constitutional rights? So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here, and if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated.
Okay, here we go.
Maybe prejudicial to one or the other. So I guess at this point.
Okay, right here, I'm going to put us to a spot where we're going to hear that it comes out, and I think Ann wanted this to come out. You guys, there was a federal grand jury. So there's a grand jury that indicted, which was not a federal grand jury. A federal grand jury did not indict Brian Kohlberger, okay? The grand jury that indicted Brian Kohlberger is just right there in Latah County, okay? At some point, there was a federal grand jury, okay? Because what they're trying to get their hands on here are federal grand jury testimony. So those of you guys who are following the Karen Reed case, in the Karen Reed case, there was a grand jury, but then there was at another point a federal grand jury. Federal. The feds were conducting a grand jury. Now, listen up, because it was like I caught it. I was like, wait, what? So I immediately make a big deal about it. I post it, like when I write it here. I was like, wait, there was a federal grand jury? Where is this said? Because I post it and I say federal grand jury and lose my shit.
1, interfere with enforcement.
So she's okay right here.
1, interfere with enforcement proceedings pursuant to 74-124 subsection. Concurrent with the defendant's 4th motion to compel discovery.
Okay, so here she's going to go through.
Feel confident that when the court does the same balancing test, it'll come to the same conclusion.
Okay.
For the record, since the beginning of this case,
okay,
attachments detailing the specific discovery request.
Okay, so what she's referring to right here is the first motion that they put in for like supplemental. I went through it the other night, guys. When she would do it, or anybody's doing it, it says, supplemental request number 1. And it goes through, gives whatever, and then it says Exhibit A under seal, Exhibit B for then the next one's B, C, D, E. Okay, so what this woman goes through right now is she decides to tell us what these are about.
have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32.
And then Anne explained this. Yeah, we were stipulating all this under seal shit for the speedy aspect of it, okay? The speedy aspect of it. Yeah, file our attachments because that's what the meat and potatoes are of the motion. So for the speedy purpose of it. Otherwise, we're going to have to look at this and we're going to have to see, okay, what do we have to redact out? So yeah, Anne's like, for speedy purposes, we stipulated so that we were going to have all of our motions, any attachment was going to be filed under seal. And Anne says it, we did that for speedy purposes, not because we wanted it sealed, and you know that, but you're trying to, spin it. This is just a spin job, okay? And then Anne comes back and says, no, we stipulated that because of the speedy purposes of it. Okay, period. Boom. Now.
Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course, we have filed all of our responses under seal, and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position.
See right there, she says, just like how those were sealed, and that's why we wanted to seal this so we could talk about the sealed material. Do you see how, like, I mean, this is the type of shit I hate, okay? Because this dumb bitch knows that Brian Colbert wasn't sealing this because he doesn't want it sealed or because he wants it sealed. And see, this is why I would never become a lawyer, because I would be getting into word matches with all these people when I would just look at them and I would be like, bitch, you a lie. Like, we didn't file under seal because we wanted under seal, because it's speedy, because neither one of us have to go look at the other person's shit. It's that way so that the filing can just be there, and because we're trying to get this process moving. You want to talk about something that would hold up a lot of stuff? Is everybody checking all their shit to see what needs to be redacted and yada yada yada,
and asking the court to ignore all the previous filings. And this is just entirely inconsistent. To be clear, the state
inconsistent. Well, for the record, she does not need to be consistent. Like, that is the weakest fucking argument. This is just inconsistent. Inconsistent. Do you know how dumb that actually sounds? That is just inconsistent. First of all, your argument blows because that's not what we're sealing. But second of all, to say that I'm inconsistent,
has nothing to hide.
She just says right there, the state has nothing to hide.
However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for a defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124, subsection A, deprive the defendant of the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for a defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation.
Look at that poker face. Look at that, of course. I didn't even make any big deal about it. Right there, I'm just like, federal grand jury. I'm like, watch me write this stuff down. Here. Just I think I'm just gonna add this in for you guys in case you guys
Of
missed it.
which disclosure would, one, interfere with enforcement proceedings pursuant to 74-124 subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124 subsection B and Rule 32 subsection E. And it would disclose investigative techniques or procedures which are exempt pursuant to 74-124 subsection E.
Okay, so we're going to talk about it. Ready? There was a federal grand jury. Who wants to talk about this? Why would there be a federal grand jury?
For defense's fifth motion to compel, item 1, subparts A through J, all deal with the investigation.
Okay, so A through J, that would be through supplemental requests 1 all the way through J takes you to supplemental request 11. Okay, and those all pertain to all dealings with the investigation.
All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject.
Okay, so then everything to do with discovery, K through M, which is discovery requests 12 and 13. Okay, these have to do with interviews, private citizens that were interviewed. So a private citizen could be someone like, I want to know if she's using the term private citizen instead of witness. Like anybody that you interview, you're interviewing them for a reason, so they would be considered like, a witness in a sense. What's the word that Idaho State Police use, though? Let me see what they call it. Let me check out one of my old handy dandy fucking reports over here. Where did I put that shit? Oh, for fuck's sake. Well, they have the subject, the suspect, and then they list them as witnesses. So everything to do with supplementals K through L, 12 and 13. When did they ask for it? This would have been stuff from March 25th, 2024. That would have been 13th. Okay. Sorry, I'm just talking all going out, a federal grand jury for what?
To 74-104 subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person.
Intimate facts? Okay.
Exempt under Rule 32 I to A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy under Rule 32 subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding.
Okay, so then now N through O, and that's going to be A, B, C, D, F, G. N through O, that would be in supplemental. So 15 had N in it. If she did a 16th or a 17th, but I have never even seen an O yet, unless N and O are in 15, but that's interesting. Okay, and now this says that it would interfere with, let me get this.
It's exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business
Okay. Item 2, subpart A. Okay.
And is exempt under the previously cited authority. Item 2, subpart B through L deals with the investigation. Again, exempt under 74-124A, subsection B.
Okay. So private businesses, their names. So, I mean, correct me if I'm wrong. Why couldn't those names just be redacted? Anyways, but B through L has to do with basically investigative tactics that would be like, we would learn about. It's interesting.
And E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt.
Number 3 now, so we're under 3 now, private businesses again.
Under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions.
Okay, so this is what they're trying to say. They're trying to say that if we go ahead and we have this and we just talk about stuff without giving any context, then people like all of us, we're going to just run with whatever. Kind of like what y'all did with like the stalking. So what's in here that we could possibly just run with? It says it's going to fuel speculation. It's going to fuel this. It's going to fuel that. Listen to what she says. Because, well, then why don't you give us I guess what my thing is when Ann Taylor's talking about whatever and you think that it's out of context, why don't you put it in context? I mean, you can't put it in context?
Assumptions and false narratives.
False narratives. Interesting. Well, the only person that's really kind of fed me a false narrative that I feel is like tied to the investigation, I felt like that I got that from Bill Thompson when he did his press conference. And then I felt like I got it from people that wherever Steve Gonsalves was getting his information from.
Undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most.
Okay, so let me ask you a question. What's the problem with me having an opinion? What's the problem with you having an opinion? What's the problem with like? How would my opinion be taken as being false? Like I can't hear what you have to say, and so you think that America and the rest of the world is just going to put what? They think very little of you guys, man. But I would just think that I wouldn't let Ann Taylor take it out of context, and I would put it in context, right? Wouldn't that be my job? Okay, like as me arguing it, you know what I'm saying? Like, what the fuck? Oh, I don't want to have to be. I don't want to like. If you have nothing to hide, who's actually going to be the one that's being ridiculed? You get what I'm trying to say? Like, who truly are you trying to protect here? And anybody says that they have nothing to hide, they have everything to hide.
Most of it likely
Nobody says that when they don't have shit.
will not be offered by either party at trial because it's either not relevant or material. The public will not have any
Okay, so listen to this. She's saying this is either not relevant or not material. Well, then, so I want to make sure I'm getting this correctly. Listen to this argument.
may not even be offered, and most of it likely will not be offered by either party at trial because
Okay, this woman is saying what Ann Taylor is seeking is not going to be offered at trial. Then why don't you just turn it over? I mean, what? I mean, do you guys, are we listening to this? Like, this is just, to me, this is Santa doesn't stand a chance with the jury, but you guys, this is not even going to be offered up. What we could possibly run with isn't going to be offered up. This sounds like Delphi, man. Have you guys seen the latest shit in Delphi? That prosecutor has some fucking balls. I would like motion lemony so that Richard Allen cannot be defended with any reasonable doubt characteristics of a defense. So I don't want him talking about third-party culpability. I don't want him talking about Odinism. I don't want him mentioning any of these people that we interviewed in our investigation. I don't want him talking about any cast reports, geofencing. He's not allowed to talk about this guy. I like literally looked at this motion lemony and about fell over because I will be talking about it. All right. And they're doing that whole trial without cameras. So, but here we go. Listen to this.
it's either not relevant or material. The public will
How is something that you put in the PCA not relevant or material? That's what you arrested this man off of. Like, who do you think you're selling this shit to, girl? Have you all, like, and how is the judge not saying right there, correct me if I'm wrong, how is something that, if Ann Taylor is asking for something from the PCA, not relevant or material when that's what you use to arrest the man? See, I can think on my toes. So, like, when I would hear things like that, like, because, like, when you're in that's like the debate. Like, you're in oral arguments, you don't know what someone's going to say to you, and then you gotta just be well versed with the facts so that you can like spit it out, right? And you got to be paying attention to like what they're saying, writing it down so that you can like attack what they said. It's very hard to do. She's just doing this by herself. Okay, you know, you see Brian. He's just looking straight forward. I get that she has the lady there on Zoom, okay, but how are you going to
will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties.
I would have oral argued that and said, how would we not have context if I'm asking for something and I'm explaining what I'm asking for, and then you're telling me, what's the issue here? Like, I don't understand that. That to me is just a head scratcher there. If you don't correct the context, that's on you. But the court should protect you because you can't oral argue, because you can't speak. So, because you don't know how to handle this courtroom and what could come your way or what you may have to explain, and that we may take it the wrong way, we should not hear a public hearing. That's what I'm hearing here. And correct me if I'm wrong in chat. Maybe I'm hearing it a different way, but I don't think I am, because that's the whole point of court, of like to a jury. One side is painting a narrative and the other side is painting a narrative, right? And so I can make a crime scene look like this, and I do this with my direct examination, and then somebody comes up and crosses you and changes it. and said, you know what I mean? So to me, I don't even, I truly can't believe that this woman's a lawyer and this is her argument, because that's what, I don't know if I'm going to be able to do a good job. And God forbid if I don't. And oh my God, everyone's going to then see something that maybe they shouldn't have because I wasn't able to spin it right. Fuck you, dude. Do your job. And if you don't, you get exposed.
The defendant does have a right to a public trial, but that does not mean the right to try this case in the media. The defendant will get his day in court, and the public will have a right to see what evidence the state has.
Okay, so this was all pre-written down what she wanted to say right here, okay? What do you mean he's going to have his day in court? His days in court are not the day of the trial when it starts. Do you guys know how important everything leading up to the trial actually is? Because that determines, the judge doesn't determine your innocence or guilt, but the judge is determining what is being decided by a jury. Like, so what the jury is able to see to then decide your innocence or guilt. And so all of this stuff leading up to then actually your trial, this is all way more important. It's like when I tell people, go out there and vote for your president. Well, do you vote local? Do you vote for judges? Why are you going and voting for your president? What do you think a president can do? He's a fucking puppet, okay? You know how many fucking, what he had to do to get in that position? This is this is just all bullshit. This is all just fucking bullshit. I sat in the same damn government class that you sat in, and I took all the same damn classes. I just didn't take the bar, and I didn't take some law classes that you took. But what you're trying to feed me is a bunch of bullshit.
That should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing.
Listen, it's not just about you either. We have to hold everybody accountable. So we need to see what the judge heard in order how he made his ruling. Okay? Because I vote for judges, you stupid bitch. All right? But you people in Idaho just want to spend your money like this. And the parents want to go to trial so quick. You guys are going to be dealing with this for years. This is going to be going on for years. Unless Brian Kohlberger is somehow dead. 4 years. Idaho citizens, you guys are going to be paying out of your asses for this. It's true.
Regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings prior to the hearing.
Think about this. You need all of this this is a motion to compel discovery. Okay, so this is what you would think would happen. I would turn in a piece of paper that says, I need all of this. I need all of this. Turn it over. Then you give it back to me. You say, we don't have any of this. And then I say, well, according to report, it says that officer so-and-so showed up and he had a body cam on and I don't have his body cam. And he said that he attached it to his report. I'm just giving you guys a layman example, okay? So in this report, he said he had his worn body cam and that he attached it and turned it in. So you're saying that you don't have this body cam? That's in a report? Well, I'm telling you, we don't have it. Okay. No, you just don't say, okay, sounds good. That's what a shitty lawyer does. You understand that? That's what a shitty, lazy motherfucking lawyer does. A good lawyer, you write up the fucking paper. It's e-filing now. It's so simple. You don't even have to go down to the courthouse to do it. Lawyers are so fucking lazy. They get paid all that money per hour. They're such lazy people, unless you got a good one. No, you do it, Ann Taylor, and you file a motion to, I have to bring it here to the courts. I have to say, Judge, this is why we believe this exists. Because of this. This guy wrote in his report that he filled out a report, had his body cam on, then attached it to this report, and he labeled it, and it's supplemental report 67, 900, blah, blah, blah. This is why we believe that this exists. So I guess we're going to have to call on Officer Smith to sit his ass on the stand to ask him if, hey, this is your report? Yep. Were you wearing a body cam that day? Yep. Did you turn it in? Yep. Who'd you turn it into? Well, this is what we do. This is our protocol. When we're done with our shift, we have to sign off. And they're going to talk about their protocol with that. They're going to talk about how they were trained to do that. Okay. Okay. So, but how does it get in the hands of the right person? Who were you supposed to turn this into? Like, they're going to go through how this all works. Okay. But you're going to get that person up on the stand. And that's how that would work, to be like, okay, so then the judge would hear that, right? And again, I'm just giving you a so simple, basic example. Then the judge can say, okay, well, this guy who was working just said that this exists. You don't have it. And then it would just come back was, well, if it existed at one point, I don't know where it's at. We don't have it. Okay. So then then you can either ask yourself, did you destroy it? But then, you know what I mean? Like, that's all admissible in court, in the trial. That's all going to be. So when she wants to say like that Brian Colbert is going to have his day in court, what the fuck are you talking about? This is his day in court too. He gets all these days. It's not just when the trial starts, you stupid bitch. And that's what you're trying to sell to a judge. And if he bought this shit, he knows that this isn't true.
The state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a.
See, no, the thing about it not being admissible is this is how you'd want to have it be admissible. I don't want to exclude that. I don't want to exclude their fuckerage. I want to expose that. But I want to have a paper trail, because what you're trying to do up and until the point that you actually go to trial, okay, there are ways, like when they're talking about the suppression of something else, it's like this. Okay, for example, the Dr. Dre case. There's a 911 call. I have it. I have the 911 call. I have actually all three of them. Okay, because it got patched through, right? But here's the kicker. Bonner County had their portion of the 911 call. Boundary County, their portion of the 911 call was recorded through Bonner County. So the two counties, they each had a copy of their own portion of the 911 call. Okay. But when I did my FOIA request to get the 911 call of the Kootenai County one, that was the first phone call placed to then be patched on through to then eventually get where it was going. There is no record of that phone call. Like the dispatch people, they said there was no phone call ever made by that number to our dispatch. There was no phone call made by any other number that would be associated with that person on that day. We don't have it. It never existed. Okay. So then you would ask the officer, the lead detective who put it in evidence, this mysterious 911 call, that, like, where did you get this? Where did you obtain this 911 call? What do you mean? I asked you a question. Where did you get this 911 call? Did you get it? Did you meet up with Kootenai County Dispatch and they send it to you in an email? It was on a thumb drive. How did you obtain this 911 call? Well, no, yeah, probably got from County County, you know, whatever they're going to say. So then you say, well, how did you get it? Where's the report? Where is the report that you wrote up and that you then stored this in evidence? Where's that report at? And you would go through a little talk fest with this guy that's your lead investigator. Then you would call up Mary Ann, the dispatch woman from Cooney County. Hi, Mary Ann. Do you recall getting a FOIA request from us on such and such date? No. Okay, well, may I approach, Your Honor? Do you recognize this? Do you recognize this document? Oh, yeah, it's an email. Oh, okay, yeah, you guys emailed me. I wasn't. I don't know what a FOIA request is. Okay, yeah. Do you recall filling? What is this? Well, yeah, it's a request. And did you fill it out? Yeah. Okay. Did you provide us with a 911 call that we requested? No. Why? Can you read why you couldn't provide it to us? Well, because it didn't exist. Excuse me? It didn't exist. We looked at the times that you said the call happened. We looked at the number that you gave us. We looked through all of our call logs that day for 911 call. There is no 911 call that we took that day at that time or anywhere in vicinity of that time frame that you were looking for. So then I would say, okay, so there is no call that you don't have a record of any of this. No. Did you ever provide this to detectives? No. Did they ever ask you for one? No. And you recall that fucking investigator back up. Okay? The jury would see all of this. Then you would ask the question, is it possible that you received that 911 call that you attempted to play for the courts when you tried to have the preliminary hearing for the arrest and detainment of my client at a preliminary hearing that was on such and such date? Did you by chance receive that 911 call from the widow who recorded the conversation with a different device? Because then we would start shoving papers in his face to say, well, Cooney County says there was no records, that this never existed. This 911 call didn't exist. So where did you get it? And then why at the preliminary hearing did you at all talk to the prosecutor and tell him to yank from the admitted evidence, the files that you were trying to admit into evidence? Why did the prosecutor say that he wanted to pull the 911 call from the record? What? Yeah, you don't recall that? Do you want to see the preliminary hearing transcripts? Go here. Here's page 64. Scroll down all the way down. Can you read that paragraph for me? Prosecutor says, Your Honor, we would like to, we don't want to admit the 911 call. What? That's Idaho. There is no 911 call. So they've been hiding a 911 call from us. Okay. I'm not saying that happened in this case, but I'm just letting you know how these motherfuckers operate. Where did this 911 call come from? There is no, so guess what? Then you put up the widow on the stand and you say, you said that you called 911 from your cell phone. Yes. Okay. Well, here are your cell phone records. Do you see any calls made from 911? Do you remember your interview with the police and you told them that you'd use this device, but oh my God, I was looking, it's not there. And Cooney County doesn't have that you called them ever. Okay. They have no record of you calling. There's no record in your phone records. There's no record in the Cellbrite that you called. So what cell phone did you truly call 911 with? Not the one that you left in Hayden on your fucking, porch? Wrapped your dog running around the yard and make it look like you're roaming or some shit. Who knows? But point being is that now you just showed the fucking jury that The person that called 911 and said she was on the phone with her husband when he was shot didn't truly call from her cell phone. Now it's from other fucking cell number or whatever, burner. And where were you really located then? Because we pulled all your data off of the phone that you said you used, but yet there's no record of you ever calling 911 from that number, from that cell phone. So where'd you call 911? What device did you use to call 911? And how come there is no fucking record of you ever calling 911 to Kootenai County? They must just keep horrible records. That's what a lawyer told me. A lawyer told me, well, Kootenai County just doesn't keep good records. I said, are you fucking kidding me? That's what you think? That's what a lawyer would think? Wouldn't you think there's a fucking issue? It's not in her fucking phone. And nor is there any Kootenai County record of it. So what is this call? Where did it come from? Is it fake? And then how come the first dispatch from Bonner County, how come she told me that the cell call came on her cell tower? She didn't think it was a transferred, passed on over to a different place. So explain that to me. So you kind of want to let things in so you could just destroy people. But this is Idaho. This is what they do. This is sick. And this woman's lying. And Ann Taylor fucking knows it. And that's what I love about her, because she's not afraid. She knows how they work. She's dealt with these people. She's dealt with them. Inept, corrupt motherfuckers. You heard Andy Taylor? Yeah, sign that Deuce Techum FBI search or subpoena. Wait, Lena, are you being serious that there was a 911 call that you found out? Wait. Yeah, but the best part about it is that lawyers know about it and detectives know about it, and they just think it's normal. They don't think that the wife that said she called 911 from her cell phone, what they found out, that they got the cell right back and that, okay, there ain't no phone call. So then your theory goes out the window that you're saying that she's with her cell phone at her house in Hayden. You can't put two and two together because she didn't make the 911 call with her cell phone. Oh, but there's this 911 call. Is there? Is there? Well, where's the chain? Where's the custody? Where did that detective go and get the Kootenai County copy? Because the Bonner County copy one and the Boundary County copy one, oh, I have those. And I was able to FOIA that fucking shit. And why does the dispatch woman from Bonner County think that it originated in Bonner County? That it was never patched through? And why did I was able to obtain all of the CAD notes that prove it all? Because she's like, I need to call Kootenai County because something's off with this. And what does she do? She dials up Kootenai County. And I got it all on record because I FOIA requested it. And they didn't know what I was up to, and they turned it on over to me. But now it's really hard for me to get stuff because they know who Lana Oriani is now. So I'm having a harder time getting stuff. Now I got to appeal stuff. Well, you know you're big time when you got the prosecutor returning your fucking FOIA requests. I don't work with schlummy at the table anymore. Literally, the prosecutors are writing me. I'm flattered. That says that I'm doing something right. Ann Taylor said it again that Brian Colbert was innocent.
Well, Your Honor,
Marvel.
right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay. Thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information, it isn't, it seems anyway, I mean, it's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get.
Okay, so what Bill Thompson, what Judge is talking about right here is he's like, okay, I'm reading both of your guys' sides to stuff, okay? Because that's the stuff that we can't see, all right? And so he's saying, well, they're getting you guys some of that stuff, right? And it's like, clearly I don't have a problem with the stuff that they're getting me. It's the stuff that they're not getting me. So this is what's funny to me is like, well, they're giving you some of the stuff, right? That's not why we're here. We're not here because of what they've given me, you dumb motherfucker. We're here because of the stuff that they haven't given me, the stuff that you arrested my client off of, the stuff that should have been the first stuff that I should have. What aren't you like? Do you want me to admonish you in front of the world? And that's what Ann Taylor's holding back. Ann Taylor has to play her cards right. Ann Taylor can't rip this man a new asshole. I mean, I could, because I don't give a fuck. Fuck you. I'm sorry, but this is wild. This is bullshit. We're not here because of what they've given me. We're here because of what they haven't given me. And then Bill Thompson's response to this is, well, we don't have to give you anything until September. And Steve Gonsalves wants to know why we're not in trial. Well, when guys give you answers like that, that's why you're not in trial. And you're not going to be in trial for a long time. Because the answers like that. Go strum your fucking guitar. He better sing, don't give me no alibis. You guys don't think I'm going to play it? Because I am. This is what I wake up to every day now. I love Eric Clapton. All right. Bella knows. Okay. She's like, did you put that as your ringtone? I said, it's my wake up in the morning. She knows. Ready? Let's see. There. That's for you, Jen. When you throw me them 50s, I dance like a stripper for you. Listen, we're going to get truth and we're going to have fun doing it. And who deserves the truth more than the victims? Period.
That information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean.
Right there. Okay, perfect. She says, so some of their answers are like, we're not even offering that. We're not offering that up during, like, that's not going to be part of our case in chief. That's not, do you think that people use, do you think I'm going to introduce evidence that's not going to help my case in court? But do you think that wouldn't be something that you would want to use? I mean, to hear this shit, I wonder, I ask myself every day, like, maybe I should go and be a lawyer in Idaho, because I love the people that I've met in Idaho, but I'm starting to seriously question the IQs of these people. Bella, what do you think about that?
No comment.
Are you saying I don't have a high IQ?
Oh, I thought you said you were
This is
people that have high IQs. I can't do no IQ.
This is insanity, man.
No, you have a high IQ. Was that the question?
I don't even know if I've ever. Where do you even take an IQ test? I've never taken one in my life.
What?
Oh, there's like a book.
My dad gave me one when I was 5.
So like you could do it online. I should take a test so that everybody could watch to see what I would score.
Yeah, but it's
Truth and transparency. Let's see how stupid Lana is. Um,
my dad had a thing for IQs when I was there.
I just, we're not planning on offering it up. I don't give. I do not care what you're planning on doing. Why would that even be your answer? But I mean, how ridiculous is that? And I think, you know, that's why I wanted to play this again so I could like slow it down so you guys could like really hear what she's saying. Oh, I'm not offering that up. Like we're not using that. Just like we're not using the IGG. I think the sheath is going to get tossed. Okay. That's what I think. I think it should get tossed. That's what I think. Or do you keep it in and do you expose the FBI? I mean, there's what, 90 ways it's going to cat, they say, or something like that.
And some of the ins and outs that go into play with those, but there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we file those under seal for expediency and saying, this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we file those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing.
Okay, so now she's like, let me just handle this, whoever, Jennings woman, let me just handle her, okay? So she handles her and she's like, she tells Bill, we know that you planted the sheath, okay? Now I'm just seeing if you guys are paying attention. She says, Bill, or she says, Judge, expedience, right? But that's not what we're talking about here. We're talking about now she's going to explain, now that she just tried to spin you, okay? Let me tell you what we're talking about. And let's see look at his face.
When the state has decided to not give us information or to drag their feet on giving us information, we're talking about a public hearing where we have a right to be in the public eye, a public hearing. Brian's the one with the right. It's his Sixth Amendment right.
Okay. We're talking about a hearing, okay? And she's using the term hearing. She's not using the term trial. This is a hearing, okay? Brian Colbert, it's, pre-trial hearing. Brian Colbert has the right, his Sixth Amendment right, okay? Because, why? Because it's just his right. Just like it's all of our right.
Right to have a public hearing. When the state wants to close a hearing for any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho.
Right here, she just basically owns him and says, okay, we object. They want to close hearing, but we object. So then the court, I'm trying to help you here, the court is guided then by case law, okay? So just judge, follow the law, follow the case law, follow precedent, okay? You have to have a really good reason, there's precedent out there. What are you doing? Okay.
In the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimberly and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 US 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening.
Okay, an overriding interest. So judge has to overcome, like that's his burden to overcome, to say that there's what's this overriding interest to close it, okay?
The court would look at Brian's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Brian's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court.
Okay, so her argument right there is that, listen, you think the state's argument is we're trying to preserve the right to Brian Kober's right to a fair trial? No, Ann Taylor's saying, no, Brian does not believe that. Okay. And the way that Ann Taylor is saying that Brian does not believe that. That's what she basically just said in layman's terms. Okay. No. And instead, it's the state that's trying to close this because the state is trying to hide, H-I, hide.
Should look back through the history of this case.
And then she asks the judge to look back through the history of this case.
Our fourth and fifth,
which there's precedent in every case already, because the way that you're doing things.
Motion to compel. Motions to compel 1, 2, and 3 were public.
Motions 1, 2, and 3 to compel. Okay, those were public. So now I would take this up Jennings' ass and I would say, hey, Jennings, you want to talk about inconsistency as you worded it? That we're now all of a sudden being inconsistent? No, y'all are being inconsistent. And you're pure narcissistic projectionist motherfucking woman. Okay? As Bella would say. I got your number there, Jennings. I've had Santas for a while. This is called 50 Shades of Red at this court. That's why I'm wearing red. Santa, they need to have him not talk to any of the people on the stand. Okay, the jury will not like this man. And I don't know. I mean, I think Jennings is bleh, but
they were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself what? And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you.
Now, money. Here we go. Boop, boop, right here.
And a half now that has been offered to be shared far and wide. And a half now that what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit.
This is where she enlightens Bill Thompson, or this is where she enlightens Judge. And the things that we are seeking, okay, the things that we are seeking are the things that are outlined in the probable cause. Well, funny that you should mention that. The cast report she talks about. She's still talking about this cast report, these videos. And then she talks about a partial video. Okay, let's listen up. Like, if that doesn't make Judge, right there I'd have a question. Wait a second, you don't have material that they used in the PCA. Why isn't that question being asked? Miss Taylor, let me understand you correctly. Are you saying that there is material that you believe that the state used to arrest your client, to obtain a probable cause for the arrest of your client, that you do not have? Yes, Your Honor, that's exactly what I'm saying. Mr. Thompson, do you have anything to say about this? Mr. Thompson, I'm going to need you to get that material to her. Wouldn't that be just like normal? If Ann Taylor wasn't giving Bill Thompson something, I would be saying, Ann Taylor, what the fuck are you doing? Like, what the hell, right?
David, that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context.
We're looking for videos. Listen to this.
Far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context. That's what they're doing when they want us to do this in private.
Right there, that's what I'm talking about. Projectionist right there. Narcissistic projectionist bitch. Okay? Right here. Ann Taylor just showed. No, that's what they're doing. They're the ones that are taking it out of context. Like, so she's the classic narcissistic projectionist. God, we're just reading people over here, man. Find out when her birthday was, because I want to know what her horoscope is.
Private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative.
Right there. Are you guys listening to this amazing argument? Ann Taylor just literally killed it.
That they haven't given us. That is the state keeping things in a vacuum to control the.
That is the state keeping things in a vacuum to control the narrative. One of the emails that I received from Steve Gonsalves told me that Ann Taylor was playing me and that I needed to get off that ship. Okay? Before it sinks.
Can I tell them that you get lots of emails?
Yeah, I get, you guys have no idea how many emails.
And these people all think that you just come out here and just say whatever.
Yeah, and then I just like run, like, because you're somebody that I'm going to do something.
Do you
No.
understand she doesn't go and like run with stuff that she has? So anyone who thinks that you can just drop something in her inbox and she's going to go live with it, that is not how it works. So
That's not how Ella works. Yeah, let me remind myself of this.
remind myself
Of these emails. Here it is. Don't get played, February 15th. I can assure you that BK was captured on camera that night, and my reference is not to Linda Lane or 1112. However, I'm unable to disclose this information to avoid betraying the trust of those who have supported me. His car is captured traveling Troy the night of. We desperately need more witnesses to come forward, who's appeared too intimidated to provide the necessary details. 2 large firms keep threatening their employees. They could be fired if they step forward and do the right thing. It has been an uphill battle due to threats from these firms, who are clearly more concerned about the negative impact on business. I'm reaching out to you because actions and half-truths create confusion, such as denying any connection or questioning how BK became a person of interest. It's frustrating, but Thompson can't refute these claims without risking the integrity of the jury pool by revealing key information. You love sticking it to the bullies, so why don't you help this girl who can't even get the cops to call her back now that BK is arrested? Gray and I are trying to figure out why they never pressed charges, being he did the exact same charge in our case. Furthermore, by making him a repeat burger, we would have a backup if anything was dropped. But they don't want the negative press, so this girl's justice was dropped like a smelly Bag of PR dog shit. Got to get back to work.
My comment wasn't directed at the Gonzalez family. It's just to everybody, like anybody. It's not directed to them. It's anyone who thinks that Lana just runs with whatever you drop in her inbox and she's just salivating to do clickbait. All the haters out there. It's not what happens. That email right there is at least maybe even close to 2 months old. And that's like,
Oh yeah,
the
that was,
latest
yeah,
of
that
the
was,
emails. She's
yeah.
been in contact with them for like over a year and nobody has known about it.
yeah. I support Christy and Steve. I want them to get justice. Justice comes from truth. I don't know if Steve has been lied to. I don't know if people have provided him with bogus information. Okay. But all I can say is that don't get played by, tell me not to get played by Ann Taylor.
All the people frantically now calling everybody, don't talk to Lana Ariani. Don't talk to Lana Ariani. You guys, she's been in contact with all these people for months.
Yeah, I don't give a
Late to the
fuck.
Party.
I
I'm
don't
really
care.
sorry to tell you. We just keep things really close to our vest here. Sorry about that. Sorry about your luck.
I feel bad because I think that he's been totally misled and misguided. And I hope to God he fucking sues the right people, because this would have me fired up. I would be calling up Bill Thompson right now saying, I want to see this all in your closing. I've been asking to put this all out in the public, and here you are yet again trying to close me off from my closure that I want. My daughter was murdered. That's what I'd be saying to that man. I'd be boycotting that Judge doesn't see another day on that bench. All the friends that Kaylee and Maddie and Ethan and Zan and all these people had, and none of them are standing out on the steps. None of them are doing a damn thing. These kids don't give a fuck, man. Who needs enemies when you have friends like this?
Greek life, yo.
Greek life, sign me up, bro. Let me see how many beers I can drink, yo.
Public narrative. And that violates Mr. Koberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Koberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Brian in the first place. That's been sealed, that's fine, we respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Brian have to have his case, when he's asking for this information, be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received.
Okay, now we get to the goods. Here's a mic drop right here. Ann Taylor killed it. Part of this is to talk about on the 14th is about the pieces of videos that they've received. Okay, because Ann Taylor has been broken off shit. Ann Taylor is getting that jank ass, like, what do you call it? That version that, like, you go to a theater and, like, you record the movie when you're at the movie theater, like, and then it's all, like, messed up and no audio, this, and then it's in Chinese and who knows, okay? Something interesting that she says here, though, I know about the cell towers, the cell drive test. Interesting. Drive test, huh? I wonder what they did for a drive test. I wonder who did this drive test. Who did a drive test? Okay. Did the state claim that they did a drive test? Because this is what Ann Taylor is asking for things. She's not trying to like give them things, right? She's asking for things. All right. So did they do a drive test? Because that's something that I would do, you know, because I would want to like, you know, but this drive test has me interested. First time I've ever heard of a drive test. You guys know those, what was it? Test drive. What was it? Test drive dummies. Is that like the artist?
And how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Brian's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts along.
Wait, they've withheld the audio from a great okay, so think about this, guys. Holy ballsack. Okay. Ring cameras have audio, right? Let me rewind this. I want to get clarity.
To talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And
that's the Linda Lane video. You guys, that's Linda Lane. It's Linda Lane and 1112. The audio would be the ring, the thud. They haven't heard the thud. Holy shit, they haven't heard the thud. Dong, 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 dong. Holy bitch. That's it. I'm making a phone call because I know those people over there. And I was able to obtain the ring camera from when he thought it was the fake cops, and that's why he went to the police. That's the neighbors. I know all of those people. I love it. Dude, I'm telling you, I've met some seriously cool ass people in Idaho, in Moscow, okay? And you know, Dave is one of them. Like, that kid's gonna make it in life. God.
we think Brian's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received.
Guys, down the hill. This is Delphi on steroids.
To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Brian has been essentially convicted in the media.
This is how I would argue that. Again, you have to go back to the PCA is public. This is stuff that what we are asking for is what they use to support their PCA. Okay, the PCA is public. The public has a right to know if the PCA is not supported. This is all going to lead to a Franks. Okay. You cannot lie in your probable cause for an arrest. You cannot knowingly lie. It is Frank's hearing. Here we go. Let's saddle up. Okay. Officer Payne. The PCA is public. Okay. And she said it, but I would be reiterating it here though. The PCA is public. And so therefore the public has a right to know about the public document that arrested my client is not factually supported the way that they claimed. And Bill Thompson knows this. That's what I think.
You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So
See, like, you miss all these like hits that she says. People have a right to know that it's not this neat little package. This case isn't a slam dunk like the media is telling everybody. And when are we just going to kill him? And wait, let's let the parents wear shirts that say like we're going to fucking gun, like, we're going to shoot you. To be honest, I don't think that stuff should be allowed to be worn in a courtroom. You want to talk about a buffer zone? Let me tell you about a buffer zone. You know what a buffer zone is out in Massachusetts? You can't wear pink in the buffer zone. You can't stand within 200. You can't wear certain things. Okay, that's what's going on right now in Massachusetts. You want to talk about First Amendment? Interesting, huh? But wow, they were getting mad about signs outside the courtroom. Nobody's saying that they're going to kill anybody and put somebody to death and let's hang them on the fucking Karen Reed and shit like that. No. But you want to talk about like what's going on in Massachusetts? Wow. The media, the mainstream media isn't giving this man a chance. He is already guilty in the media, you dumb judge. I have you have to afford me the right to rehabilitate that as his defense attorney. It is in Brian Koberger's best interest, my client's best interest, to rehabilitate his image with the public. Because we don't know where this is going, Your Honor. It sure as hell ain't staying in Moscow. Take it to the closest airport.
people can start to wonder if Brian's innocent. Your Honor, Brian is innocent.
Ooh, there you go.
And he has an absolute.
Look at Lana sitting on the sidelines. You would have thought someone just hit a 3-pointer. Watch this.
Package. So people can start to wonder if Brian's innocent. Your Honor, Brian is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being. Right there, Anne said so perfectly. And I'm going to pick this rest of this up a little bit later. I got to take care of some things. And that way we can all discuss at a later time. You guys can watch on your own, come with your thoughts. I'll actually drop the link when I hear what you guys have to say. But right there, the state is hiding behind Brian's Sixth Amendment. You scared pussy ass bitches. Yeah. This is the only people you need to be suing, Mr. Gonsalves, right here. It's right in front of your face. Go sue. Wrongful death. Right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you.